Attorney General.
Thank you very much, Mr. President. Mr. President, I'm pleased to take the podium to wind up this debate on this transformative bill and acknowledge the contributions which have been made today. May I address some of the issues which were raised by my senatorial colleagues on the other side? The removal of cross-examination has been raised as an issue before this honorable chamber. Curiously, there is a very recent case, the State against Curlin George, criminal appeal number 2 of 2011, decided in February 2023. February 2023, this year. Practicing criminal attorneys at law ought to be aware of the well-established position that a preliminary inquiry in our current disposition, a magistrate is not entitled to consider the credibility of witnesses and their account of facts. That was the decision in the State and Curlin George. So I fail to understand the insistence by criminal practitioners who stand here today recommending the precedent of their experience to suggest that by this bill, reducing to very limited terms any entitlement to cross-examination is somehow unfair to the accused, because in the current law as it exists, decided at February 2023, that is not a relevant consideration. And what this bill is simply doing is to codify into law the misuse of preliminary inquiries by removing the process of wasteful cross-examination at the pre-trial stage. Another area, Mr. President, which has been flagged for attention is the fact that I've spoken to the proclamation of the legislation, and it has been said that, well, the government passes laws but are not proclaimed. Senator Lachmedia cited one act, the Evidence Act, as being unproclaimed. That is ungenerous, if I may say so, with respect to the massive work which has been undertaken by this government and justice sector agencies to implement several laws which have been passed and are in effect. In fact, by legal notice number 99 of 2022, Section 12AG in Section 4 of the very Evidence Amendment Act and Sections 6 and 7 of the Act came into operation on Monday, the 2nd of May 2022. My office has worked with the Trinidad and Tobago Police Service, Mr. President, to support the service's preparation for the intended operationalization of this act. That support commenced in 2021 and included the provision of draft regulations to the act for the consideration of the police service. The police service would require the implementation of requisite processes and procedures in order to achieve full compliance with the Act. And in this regard, the Office of the Attorney General remains committed in the provision of support to the police service for work that is being done to support that service's preparation for the intended operationalization of the Act. The proclaimed provisions deal with admissibility of CCTV recordings, the admissibility of electronic evidence in any criminal proceedings, and ensuring the prosecution has an independent right to give a closing address. Those are the proclaimed provisions of the Evidence Amendment Act. Beyond this, if I may remind Senator Lachmidial of some of the major laws which have been implemented as part of this government's ongoing and comprehensive approach to justice reform. The criminal procedure plea discussion and plea agreement legislation. My office has a working committee of all justice stakeholders, Mr. President, including representatives from the Office of the Director of Public Prosecutions, the police, the prisons, the criminal bar, the law association, and the judiciary, who meet regularly to ensure successful implementation of that law. We also have the Miscellaneous Provisions Trial by Judge Alone Act, which is already law, and there is a bill before this Parliament to improve that law. But it is already in effect, and under that law, which was proclaimed, over 60 judge-only trials were elected by accused persons since proclamation of the law in 2019. And importantly, judge-only trials were the only mode of trial which was possible during the pandemic. So the country did not grind to a halt. The justice system continued to work as a result of improvements implemented under the watch of this government. The Criminal Division and District Criminal and Traffic Court Act transformed the operations of the former Magistrates Court and created the position of master. The Miscellaneous Provisions Age of Retirement for Judges, Interpretation and Chief Judicial Officers Act 2020 raised the age of retirement for judges from 65 to 70, thereby ensuring longer judicial service of able men and women with agile minds and a commitment to doing justice for the citizens of this country. The Miscellaneous Provisions Supreme Court of Judicature and Children Act 2018 amended 13 pieces of legislation to allow for the streamlining of the processes as it relates to the treatment of children and children matters, all of these being proclaimed and in effect. The amendments also made provision for an increase in the complement from 13 to 36 High Court judges, 9 to 12 in the Court of Appeal. This is the largest increase to the statutory complement of judges since this country became independent in 1962. The Family and Children Division Act 2016 created the Children's Courts, which provides specialized expertise and resources to address the unique complexities of family and child-related legal matters, ensuring better protection of their rights and their welfare. The Administration of Justice Electronic Monitoring Amendment Act 2020, which created a system of enhanced supervision and accountability through remote tracking and surveillance and is in effect. The Electronic Payments Into and Out of Court Act 2018 allows for electronic payment of all fines, all fees, and trust accounts, example, maintenance payments. Physical cash is no longer needed. Mr. President, these are just a few of the laws passed by this Honourable Parliament at the behest of this government, which are in effect. And I said at the beginning, when I commenced the piloting of this legislation, that we should avoid politicizing a worthwhile endeavor. And worse than that, we should avoid misleading the listening public that the hard work of this legislature is not being implemented. It is implemented, it is proclaimed, and it is doing better for the citizens of this country every day. And that is what we are here about today. Heavy weather, Mr. President, was also made of the perceived lack of resources and training with specific emphasis on the DPP's office. Of course, I acknowledge that I am an easy target for persons who think that I make an easy target, to the extent that there are perceived differences between myself and the Honourable Director of Public Prosecutions. But without prejudicing the ongoing engagement that continues between myself and the Director, I can say without fear of contradiction that several processes, infrastructural and human resource efforts are underway to enhance the capacity of the Office of Director of Public Prosecutions. And I am not going to speak of it beyond this, because I don't want it to become part of a political circus before it brings the results home that this country deserves. We ought not, Mr. President, as a parliament, allow persons to cause unfounded fears of insufficient resources to prevent this law from coming into effect. I can't understand, frankly, how responsible persons can stand here today and say, because of all of the teething pains that we are experiencing as a maturing country, we must not take steps to improve our condition. I simply do not understand it. I fail to follow the logic of that myopic approach to government. This very law is meant to ensure that resources are better utilized in the justice sector through a more streamlined and efficient system, so that in the virtual court system that we now have, I heard Senator Welch, the last speaker, speak about the fact that the preliminary inquiry should be left with the magistrates, because we have magistrates spread across the country and he doesn't know how many masters there are. But in the High Court, and I pay tribute to this, the superior quality of efficiency that is taking place in the High Court right now, we have a remarkable digital justice system that is allowing for courts being held, matters being heard, persons being given trials virtually across the nation without having to physically locate people in a particular place or places. That is why the country's justice system did not come to an end with the start of the pandemic. I just returned, Mr. President, from an eye-opening experience in Spain. Compliments of the IADB, I visited Spain with a group of 6 other countries. We were Trinidad and Tobago was the only English-speaking country to participate in Spain's digital justice tour of Spain, to learn from and understand what is taking place in Spain, Uruguay, Chile, Peru, Panama. And I was very proud to come away from that experience to recognize, and to have other persons recognize, that Trinidad and Tobago's digital justice system is on par with, and in some cases ahead of, some of those other countries. And it is the future. Digital justice, electronic documents. Just today, my daughter wanted to make an application for a particular document. She was able to go on her computer and make the application and have the document downloaded. She did not have to get into a car and deal with the traffic and drive to Sangre Grande, or attempt to get to Sangre Grande for the document she needed. That is the present, which is now our future. that our judicial system is engaged in. So when we speak about the masters of the court dealing at the initial hearing and at the surveillance hearing to process the pre-trial stage in 6 months, I fail to understand the comparative attractiveness of saying we have magistrates in all of the districts who are not yet digitized. That's a work in progress. So let us leave them with the job because that's what I'm accustomed to. That is not progress. Mr. President, as a parliament, we must acknowledge that the current preliminary inquiry system does not serve its purpose. I said that at the beginning, I say it now, and I will continue to say it. It is detrimental to accused persons, to victims. It wastes precious judicial time and resources and causes unjustifiable delays in the resolution of serious criminal matters. Senator Welch himself said when he uttered to his colleagues abroad that he had a case that was 15 years old, they thought he was joking. Well, that's what we're trying to fix. Does the system need a change now? The answer is an unqualified, all capitals, Y-E-S, yes. Does this bill provide a workable solution? And that the answer again is a resounding yes, Mr. President. If I can clarify to move to another subject, some issues that have been raised in relation to the interpretation of Communications Act, Clause 7. That clause proposes to insert references to sections 13 and 14 of AJIPA, the Interpretation of Communications Act, into this bill. But it is introducing references to communications data, and stored communications, which already exist under the present law that is now being amended. It's not new. The only amendment that was introduced, and I introduced it in the House earlier this week, is because we had left out the term stored data from the group communications data and stored communications. But that's already the law, and we simply added in stored data because by an error it had been left out. That's not new, that's not now been introduced. That is the existing law. And more than that, scaremongering, the idea that communications data, and stored communications is to be said to be synonymous with intercept is just wrong. It's plain, patently wrong. Access to stored communications data does not have anything to do with intercept, which is another definition in the AJIPA legislation, and I'll read it. It appears, with your leave, Mr. President, in Section 5 of the Interpretation of Interception of Communications Act. Intercept in relation to a communication means listening to, monitoring, viewing, reading, or recording by any means such a communication in its passage over a telecommunications network without the knowledge of the person making or receiving the communication. Well, nothing in this act is adopting or borrowing from AJIPA the term intercept, and it is not introducing that in this act. It is significantly different, if we take the time and the trouble to read and to understand what we read, different from communications data, and stored communication. So under Section 5 of the Act, the master will issue a search warrant to seize a mobile phone because he suspects that there may be something stored on that phone. It is not going to be given the police or anyone, the registrar or anyone, the power to seize that, to listen to anyone's communication, but simply on the definition of the power of search and seizure in Section 5.2 to give the police power to seize the instrument, to see what may be on that phone that is relevant to suspicion of the commission of an indictable offense. Nobody is going to be listening to anybody's conversation. Another critical issue raised is the requirement for the filing of the indictment at the start of the pretrial process, Mr. President, instead of at the end. I heard concerns uttered of the fact that there is a likelihood that the charge may be changed, by the DPP when evidence is led in the pretrial stage. I don't understand. How are we criticizing, allowing the indictment to be laid at the beginning as a criticism on improving our justice system? The time has come for a culture change and a process change. It is to the benefit of the accused to know and to be ensured that before he is charged and brought to the courts and deprived potentially of his liberty, that all relevant state agencies are mandated to comprehensively prepare to charge and move this matter through, either to acquittal or conviction, as the case may be, at the first stage. What is there unfair about that? That an accused at the beginning of the process has the confidence that the indictment will be filed so he knows what he has to face. And we have to also understand what is the purpose of an indictment. It is meant to inform an accused of what they are charged with, particulars of what they are charged with. What justifiable reason is there for not allowing the accused to know, in the legal language, ab initio, from the beginning, what he is charged with? How can that be objectionable? Mr. President, the new system ensures that the police gather all the necessary evidence against the accused before a charge is laid, and therefore the indictment can be properly informed based on the evidence against the accused. In the event that the DPP must amend the indictment for whatever reason, the DPP powers to review, amend, or change his mind about charges is, of course, supported by the evidence provided for in Clause 2625(1)(b). Concerns have also been raised about the either-way offenses and the right of the accused to elect the mode of trial. The mode of trial, Mr. President, as we are reminded in Hilroy Humphreys, is a procedural element of the pretrial process which does not impact the accused's substantive right to a fair trial. We are not depriving the accused of his right to be heard or of a fair trial. What we are doing is streamlining processes and upholding the DPP Section 90 power of prosecution. The court in which a matter is to be prosecuted ought to be left to the DPP, who brings the case, brings the charge before the court. Mr. President, there is a remarkable suggestion that this bill is simply moving the bottleneck to the High Court. This is a gross underestimation of the decades of consultation and policy development which has been undertaken through my office and my ministry by all those who are committed to perfecting this bill for more than a decade. There has been, and I've spoken to it, a consultative process that has involved the Office of the Director of Public Prosecutions, the Judiciary, the Public Defender's Department of the Legal Aid Authority of Trinidad and Tobago, the Trinidad and Tobago Police Service, the Law Association of Trinidad and Tobago, the Criminal Bar Association, the Criminal Justice Committee chaired by the Chief Justice, which has all of those personalities I've already identified as part of that committee, added to which there is the Office of the Attorney General, the Chief Magistrate, and the Commissioner of Prisons. Are we seriously suggesting today that one or two attorneys' personal experience of how they conduct their practice is superior in wisdom to a decade of consultation of all of these organizations who have worked with my office to perfect this bill to bring before this Parliament? Let us get real. This bill is intended to work in tandem with other legislative amendments. It's not a standalone one-trick pony or a magic wand. It is intended to work with a suite of other laws that have already been passed, that are on our books as we seek to perfect our system, and it's a work in progress. With stronger, better prepared cases, Mr. President, we anticipate that the system will not be inundated with trials and instead will operate like other systems in other countries where the majority of matters are disposed of fairly and expeditiously at an earlier stage, even before the full trial commences. And that is going to benefit, as I said at the beginning, the accused, the multiple accused, the victims, their families, persons who languish in remand yard for 2 to 3 to 10 years. What advantage can there possibly be for us to tell ourselves that we must not at least try? I was asked, Mr. President, to provide Thank you, Mr. President. I was asked to provide examples of what documents may be the subject of anonymization. Mr. President, let me first of all underscore that the anonymization which is spoken to in this bill is not a new concept that is being introduced by this bill for the first time. When we read the bill, we see that anonymization, by its definition, is taken from the definition of other existing legislation. It is already part of our law. It is already part of our law in relation to sexual offenses cases and documents which give details of children. It is to protect the identity of persons who are vulnerable. Another example is the need to protect the information that involve state witnesses and those under justice in protection programs. In anonymization, the court and the parties, including the accused, are aware of the names and details of the documents, but the essential protection which is being afforded under this bill is to protect against public distribution of the information. That is what the anonymization is geared towards. It's not to make for and keep secrets and expose people to charges and not know who their accusers are. Let's read the bill. Let's understand it. Mr. President, in order to ensure stakeholder readiness, the government has for the last 12 years engaged key stakeholders. I've been over that more than once. I'm not going to repeat it, but I say it only to reassure Senator Welch that I did not speak to the time between the passage of the bill here today and proclamation to engage in further public consultation. The consultation has already taken place. What I said was it would prepare us to sensitize persons who have to work within the system. And I can give this court the assurance that my office is working even as I speak. Well, not as I speak, it's after 6. But in the course of our normal work days, we are having training sessions with the police. We are supported by the UNDP and other international agencies in sensitizing the stakeholders who are going to work to deliver the justice system that this bill is going to contribute to. I think I've said enough, Mr. President. I would ask this bill to support the government in passing this bill into law, and therefore, Mr. President, I beg to move.
Honourable Senator.